Okay, good afternoon, everyone. My name is Irina Ponomarenko. I am a new assistant professor here at the College of Law as of this fall, and also a member of the Speakers Committee. I am pleased to welcome you all to the kickoff lecture of 2025-2026. The chair of the Speakers Committee, Professor Dwight Newman, is unavailable today due to board meeting, but also welcomes you all to this kickoff lecture and looks forward to talking further with our speaker today. As we gather here today, we acknowledge that we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. I would like to begin by thanking McKercher LLP for sponsoring this lecture. Their sponsorship allows the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school community. I would also like to thank Katie Richard for her outstanding organization work that she did on this lecture and for her ongoing contributions to this speaker series. So today's lecture, Breaking Up is Hard to Do, will look at the constitutional law and politics of provincial separation in the context of current controversies. Our guest speaker today is Professor Eric Adams. Eric Adams is a professor of law at the University of Alberta Faculty of Law, where he was also Vice Dean from 2019 to 2022. He publishes widely on Canadian constitutional law, theory, and history, among other topics. He has won multiple awards for his teaching and research, and he is a frequent media commentator. He is always a reasoned and thoughtful commentator throughout his various roles, and he is a real credit to Canadian legal academia overall. He co-authored a book, Challenging Exile, Japanese Canadians and the Wartime Constitution. It is set to appear next month, so watch for opportunities to buy that forthcoming publication soon. So please join me in welcoming Professor Eric Adams.
Well, thank you so much, Irina. I was really touched by the introduction until it got to the part where it said I'd be entertaining, and then I got nervous. It's such a pleasure to speak, and I want to thank the college for this invitation. It's especially gratifying to do so at the fresh start of a term, and for me, especially to do so in this esteemed law school, famous for its history of outstanding constitutional scholars and thinkers. I'll say, too, that my positive impressions of this legal community and this law school has been influenced by my longtime colleague, now sadly retired and departed from the U of A, but we borrowed her from Saskatchewan for the first 15 years of my career, Tamara Buchwald, who's in the audience, now a member of the University of Saskatchewan Senate. Professor Buchwald was a model for me in her law teaching and her approach to the profession. She was always a model of pragmatic good sense, generosity, care for others, and principled thinking. All those attributes, by the way, I associate with good constitutionalism. Finally, I know he wasn't able to be here today. How convenient, but I want to thank Professor Dwight Newman for the invitation to come and speak on this topic. It's daunting, as some of you will know, to try and keep up with Dwight's productive scholarship in the field of constitutional law, although I try. And sometimes I even agree with him, which is nice. My wife made me promise that I wouldn't sing any of the lyrics to the song Breaking Up is Hard to Do, so I won't do that. But I will say that the title of my talk today carries at least one important truism and a running theme of my remarks. Breaking up a country and its constitution may be hard. It should be hard. It must be hard. But it's not impossible, and it shouldn't be either. In our constitutional tradition, the Supreme Court of Canada wisely held in the secession reference, legality and legitimacy are linked. Our constitutional history, the court says, demonstrates that our governing institutions have adapted and changed to reflect changing social and political values. This has generally been accomplished, the court said, by methods that have ensured continuity, stability, and legal order. Flexibility on the one hand then, and change together, both formal and informally, but also stability. Those are hallmarks of our successful constitutional arrangements. Navigating the balance points between change and stability, as between unity and diversity, that's the constitutional project of Canada, in my view. It's also, frankly, just the everyday law and politics of constitutionalism. And it's the challenge that we must rise to as members of the legal profession, including, in my view, law students. So today's talk is about the challenge in the face of rising political movements for provincial separation, of holding on to those ideals. Let me say a little bit about how I'll organize my remarks and then get to it. I'll start by first briefly examining the present state of the constitutional politics of separation, principally by drawing on the example I'm most familiar with, Alberta, where I live. I'll next turn to the story of how we got here, the long history of fractious constitutional politics that has always been a feature of Canada and to some extent define us. I'll then turn more directly to exploring how the sharpening rhetoric surrounding our Constitution, both politically and judicially, has an impact, and I would say unhelpfully so, on exacerbating constitutional tensions within our federation. Finally, I'll conclude with some reflections on the constitutional rules of the game as proposed by the Supreme Court of Canada in the secession reference, and what they tell us and what they don't tell us about the various paths that a provincial independence movement might ultimately take. Let me begin with something that I can't talk about. In August of this year, after I arranged to give this talk, I was appointed by the Court of King's Bench of Alberta to serve as amicus curiae in the ongoing legal proceeding in Alberta about whether a proposed referendum topic in Alberta about Alberta independence complies with the legal requirements under the Alberta Citizen Initiative Act, the legislation in that province that enables citizens to propose constitutional referendum questions. To assist the court in its deliberations, in order to have the benefit of full legal argument, the court has asked me to take the position that the proposed independence question in Alberta does not comply with the Act. The hearing is scheduled to take place in November, and Justice Feasby says that he will issue a decision in that matter before the end of the year. So if you're interested in watching the developments, you may not have that long to wait. Obviously, this matter is still before the court. It's not appropriate for me to comment on that proceeding, and I won't, given my role within it. And I just want to be clear, nothing that I say here, which are my academic views on the larger constitutional issues, nothing should be construed as speaking to or commenting on that case or the arguments that I'll make there. Okay, that legally necessary remarks aside, let me talk a little bit about where we are. Here's the Globe and Mail from yesterday. So this is history unfolding in the present. As you may know, this summer the government of Alberta struck the Alberta Next panel to tour Alberta communities and discuss various provincial policies to respond to what the panel calls, in its words, quote, Ottawa's continued attacks on Alberta's economic well-being. Since her election as leader of the Conservative Party of Alberta, replacing Jason Kenney then as leader of the party and ultimately as premier, Premier Daniel Smith has made a signature of visible and frequent confrontations with the federal government and criticism of a number of federal policies and laws, largely in relation to environmental and firearms regulation. Some of this, on her part, I think, is deliberate political strategy. Premier Kenney lost his hold on the party in Alberta as a result of governmental health restrictions during COVID, but also a perception in that party that he was insufficiently tough on Ottawa. Premier Smith won the leadership of the Conservative Party by capturing that disaffected support of a prominent wing in the Conservative Party of Alberta. And it certainly motivated the first law that she enacted when she became Premier. You've probably heard something about the Alberta Sovereignty Within a United Canada Act. There's the famous non-handshake that we talked about in Alberta. I don't know if it made it over the border into Saskatchewan, but it was big. It was big news for 48 hours. She eventually, by the way, does shake that hand after she looks at it for an awkward moment or two. The title of that legislation, the Alberta Sovereignty with a United Canada Act, reveals something of the delicate needle that she is attempting to thread. How to maintain support with the separatist elements within her party and her base of support while not losing those other factions of her party and the broader public and province with a strong attachment to Canada. This, of course, is not simply an Alberta issue. I don't know how many have seen these billboards or how prominent they are in Saskatchewan, but this is playing out in Saskatchewan politics too, although I think at the moment more forcefully in Alberta. That's my sense, at least. You can tell me if I'm wrong about that, than here. Composite polling data on just how broad this support is for provincial separation in these two provinces suggests that there's a range at work. The polling here suggests something as high as possibly the mid-30s in Alberta, a little lower in Saskatchewan. This data suggests that these two provinces may even be higher than Quebec. I'm skeptical about that. The most recent polling data I've seen out of Quebec suggests that provincial separation is back in the kind of low to mid 40% range in Quebec. And it's clear, however you look at these numbers, and whatever the actual number may in fact be, that there is real political movements in Alberta, Quebec, and to some extent in Saskatchewan, in which the public is at least willing to consider provincial separation as a political position. Given its history of these movements in Quebec in particular, I think it takes its most sophisticated political character in Quebec itself. Quebec, I think, is different from Alberta and Saskatchewan in these regards. Are we good? What's different about Quebec? Well, Quebec has an established separatist provincial party, and Alberta's separatist provincial parties have achieved next to no political support. They exist, but still, to this moment anyway, on the margins of political success. In Quebec, the secessionist movement is a political force. It consistently dominates at the federal level in the Bloc Québécois, and the Parti Québécois has held government on numerous occasions, won numerous elections on sovereigntist platforms explicitly made to the public and voted in on that basis. By all accounts, they are poised to win the next provincial election in 2026. So there's a degree of political organization, I think, that sets these movements apart in the prairies as in Quebec. But it's also the case that that dynamic may be shifting in the West. Let me allow you just to read the words of Preston Manning, the eminence grise, I think, of the conservative movement. I'll give you a moment to read a portion of his op-ed in the Globe from this spring. Always dangerous to make predictions about things that will happen, but the ifs in this op-ed are because he's writing just before the federal election in which, I don't know if this is going to be surprising anybody, but Mark Carney did win, and the Liberals held office and were returned to power. And so some people have begun to say, again, in the Alberta separatist movement, where's our conference? This has come to pass. It's time to move the wheels on Alberta's exit from Canada. And when a figure with the political legitimacy of Preston Manning, he's a former leader of the official opposition in the House of Commons. He has immense political influence in the provincial government and at the national, and we've seen recently international level, when Preston Manning is saying it's time for Alberta to separate, which I think is the implication of this op-ed, then it's hard not to think that this is a political movement, at least that you have to take seriously and should be taken seriously. So the movement is real. It has political influence, especially within the Conservative Party of Alberta, although it's not yet entirely clear it has independent political popularity when put to voters. So I'll just offer that as the final caution. In the most conservative riding in Alberta, there was recently a by-election. So this is not the Pierre Poilievre federal by-election, but there was a provincial by-election in a very conservative riding in southern Alberta. The Conservative candidate won easily, handily, that by-election, as everybody thought, but all eyes were on the Alberta independence candidate in that election. And that individual received just less than 18% of the vote and came third. The NDP came second in that riding. So for the moment at least, notwithstanding all my comments about Preston Manning and the legitimization of the movement, politically we have not seen electoral success. Of course, that may change. Let me turn then from that snapshot of the present to the past. It seems to me important to remember in these moments that constitutions necessarily change, and that those changes take many forms over time, both formal and informal. Every law student learns about the living tree of our Constitution, but it's not just through those informal mechanisms that constitutions change. Canada once looked like this at the time of the Constitutional Act of 1791. To the people living in 1791, this seemed like a version of Canada that would last into the future. Here we see a map of that time, signaling the mix of constitutionalisms that comprised Canada in that moment. Recognition of the Indigenous peoples that govern these territories with their own constitutions and laws since time immemorial, overlaid with a blend of French law, the company law of the HBC, and British constitutional acts from the Westminster Parliament. All of that made up Canada's Constitution in 1791. Canada's Constitution and the relationships it both navigates and fosters is not static. It never has been, it is not going to be. And neither are ideas of provincial independence or wanting not to be part of that larger project new either. This is Joseph Howe. He was elected Premier of Nova Scotia right after Confederation. He swept virtually every seat in that province What was his platform? We must leave Canada immediately. Canada is bad for Nova Scotia, said Joseph Howe. And that was an immensely popular political platform in 1868. Here were his complaints. Canada has been dominated by the interests of central Canada, Ontario and Quebec principally. The Federation is a bad economic deal for Nova Scotia and smaller provinces. We are getting the raw end of the stick. And Nova Scotia has a distinct provincial identity that is not going to be well served, represented, or respected in the national institutions and values and preferences of Canada. That's pretty familiar. Many in Quebec in particular have been making similar kinds of arguments for decades. I lived in Montreal during the 1995 referendum, and I knew immediately that that vote would be close and that Canada was in some trouble when I saw how terrible the no signs were against Quebec independence. Busy, awkward, uncool, and they were sort of like curling at the edges. They just looked terrible. And then the we signs, which popped up all over my hip Montreal neighborhood, and they were bright and colorful and creative and awesome. And I said, I think maybe I should vote for independence on the signs alone. This seems like a movement with some legs behind it and some force of politics that is just the ineffable stuff of when you feel momentum in a political movement. Well, as you may know, it was as close as a vote could possibly be. Just over 50% of Quebecers voted no, despite the bad signs in that referendum. And we may be on the cusp of another separatist vote in Quebec if they hold a referendum, as the Parti Québécois says that they should, in the next few years. And it's also, I think, helpful to remember, as I try to do, that Alberta has had its intense, fractious disagreements with the federal government before, too. This is Lieutenant Governor of Alberta, John Bowen. In the late 1930s, the government of Alberta evicted him from that house. They sold off all the furniture within it. Why did they do that? Political retribution to Bowen because he had reserved his signature on some bills that the legislature had passed dealing with the federal regulation of banking. And Bowen took the position that those bills had already been disallowed at the federal level by the Governor General, and when the legislature attempted to reintroduce them as a kind of in-your-face, if you disallow those acts, we're just going to keep reenacting them, he used his constitutional powers to reserve his signature and found himself shortly homeless thereafter. So these are old tensions. It's what it means to live in a diverse federation in which power is held, sometimes very far from the provinces and our provincial governments. And I think it's not new that we feel disagreements about political matters of how to live amongst one another well. But at the same time, I think it's also true, how can you not observe that there is a sharpening of the political rhetoric with which we live. That political rhetoric, more fractious, sometimes more violent, it seems to me, has been accelerated by, I think, the pandemic, but also by the social media's capacity to both inflame people to their maximal state of anger, but also to isolate one another from each other's diverse views. We are increasingly communicating just to people who feel the same way as we do, at least in the social media world. And I think it's also fair to observe that many of the political disagreements that are playing out, which again, in large part, I would often describe as the normal stuff of politics, have increasingly taken on a kind of existential framework. This, in my view, has the inevitable consequence. Once existence, the right to exist, comes into the political conversation, it's difficult for that conversation not to immediately shake the foundations of our constitutional law. So let me provide some examples of that. In 2020, you noticed maybe that I said this summer we have the Alberta Next panel. And I think they meant Alberta Next as in what comes next for Alberta. But the other way that the Alberta Next panel, I think, is accurately described is we already had this panel 3 years earlier. We called it the Fair Deal panel. It had the same motivation, and it also traveled the province of Alberta asking the same kinds of questions. And they released a report in 2020 in which you see, again, this move to frame our disagreements in existential terms. The rest of the country, we are told in the Fair Deal report, wants to eliminate our way of life. I have some family in other parts of the country. I don't think that that's their view of Albertans or their family members that live and work there, but that's, again, the way that these disagreements are being characterized. In that same year, the Buffalo Declaration, which was issued by 4 members of Parliament from Alberta, indicated that if respect was not forthcoming, independence was the answer, and that Canada was in a kind of crisis. Maybe most starkly, from my perspective, this influence touched the legislative debates in Alberta. This is from the debate during the passage of the Alberta Sovereignty within a United Canada Act. And Jason Stephan, a member of the Legislative Assembly, also a lawyer, a member of the government caucus, indicated that if effectively, don't have to read very deeply between the lines here, that the federal government was akin to the Nazi Party of Germany. And that was not the only allusion or likening of the federal government to Nazis during the Alberta legislative debates. If they are Nazis at the federal level, then they must be violently resisted. And again, some of the rhetoric in those debates were explicitly violent in nature. We must punch back, that kind of thing. I don't think courts have been fully immune either. This is just not the rough and ready of the political game. This is the Alberta Court of Appeals decision in the Reference Impact Assessment Act. The majority of that court found the legislation, Parliament's legislation, unconstitutional. Here's what they said about it. It's an existential threat to Alberta of a clear and present danger. It's placed Alberta in an economic chokehold, said the Court of Appeal. It had rendered worthless Alberta's natural resources. It took a wrecking ball to the constitutional rights of Albertans, and it was tearing apart the division of powers. Note in each instance the underlying almost violent or literally violent imagery that's being portrayed here. And again, when we speak about our disagreements in this way, there are, in my view, consequences. Now, I'll pause here to say, I think the majority was right in its outcome in that particular decision. I thought the drafting of that particular bill at the federal level was overbroad in its the way it described federal impacts as being all falling within federal jurisdiction. I agreed with the outcome, but I was distressed by the way that the court described that decision. And I'll give you a contrast. Here's the same outcome. That decision was upheld, at least in its in finding the legislation invalid by the Supreme Court of Canada, a majority of that court. And Chief Justice Wagner writes in the language of constitutional law, appropriately so, that of course, parliaments and legislatures have to act within their respective constitutional jurisdictions, and it is the duty of courts to police those and guard those boundaries. That, I think, is what is required of us in this profession, to speak in judicious tones, even when we're impassioned on topics, in the language of law, and not in the hyperbole of war and attack. And I think there are consequences for not doing so. Just before she became Premier, Premier Smith adopted what was called the Free Alberta Strategy, which again used this language of attack to center its claims. It was authored by several individuals, but one of the most prominent was Rob Anderson, also a lawyer, now the Premier's Chief of Staff and most important advisor. Mr. Anderson's Free Alberta Strategy had the Alberta Sovereignty Act as its centerpiece. Its earliest version was more radical than what ultimately was enacted by the legislature, but look at the idea that it presents, that the province has the power to reject, override, and ignore federal laws and the decisions of superior courts when it simply disagrees with them. In defending that vision of the Sovereignty Act, Barry Cooper, a professor at the University of Calgary, and again, one of the individuals I think responsible for the Free Alberta Strategy, defended it in the National Post saying, I'll paraphrase a little, you can read his words, its unconstitutionality was the point. And this is elsewhere in that editorial, that power was more important than law when that law was illegitimate. And that power, it was time to assert that power at the provincial level. Why do I think that is not the law in Canada, that power has the exclusive role in shaping our constitutional fates? I say that because of the Supreme Court of Canada decision in the secession reference and our broader constitutional commitment to constitutionalism and the rule of law expressed in many of the court's judgments. In the secession reference, we now often read it for the 4 unwritten constitutional principles. That's how it's excerpted in most first-year law textbooks. I think that's the thing my students write down. There are 4 unwritten principles when we read that case, but I think its underlying meaning is far more significant than that. What does the secession reference say at heart? It's that Canada rejects revolutionary constitutionalism. It's simply not legal in Canada. In that decision, the court denies the capacity of power alone, even when backed by a democratic majority, to alter the formal Constitution of Canada. There is only one path to formal constitutional change in Canada, and that's the amending procedures outlined in the Constitution itself. And that means that no province can leave Canada and become an independent nation without altering innumerable provisions that tie all provinces together and to the broader federal structures in that constitution, including the place of the Crown within the Canadian constitutional order as represented by the lieutenant governors of each province. Independence in Canada, that means, of a province cannot occur without unanimous provincial consent operating under the powers granted under the amending formula of the Constitution. But recognizing the powerful ways in which law and politics are connected, in the secession reference, the court outlines actually some extremely wise statecraft. It's not just about the power of the amending formula to prevent constitutional separation. The court also says that, yes, if there is a clear majority that votes to separate, then there is no choice on the other parties to Confederation to begin negotiations. And those negotiations must lead to some kind of constitutional change. Although the court says the actual outcome of that constitutional change is for the parties and those negotiations to decide. Now, there's a handful of references in that decision to Indigenous peoples and their rights. There were interveners in the reference case, the secession reference case, that made the argument that Indigenous peoples needed to have a say in any potential constitutional change involving Quebec, and that if Quebec was divisible, then it was also, if Canada was divisible, then Quebec was also divisible, and that Indigenous peoples might, in governing those lands, choose to remain connected to the Crown. The court gives only a handful of references to what the role of Indigenous peoples in those constitutional negotiations are, but they recognize that Indigenous peoples must have a role. Now, in 1998, that was thought of in the moment by many as being a progressive recognition of Indigenous rights. We, I think, all know that the place of Indigenous peoples in Canadian constitutional law has developed dramatically between 1998 and today. So the concept of the honor of the Crown, the duty to negotiate, the place of Indigenous peoples in the solemn promises of treaty relationships, all of that case law, all of the recognition of Aboriginal title, Aboriginal sovereignty, and the crucial place that Aboriginal and Indigenous peoples have in our constitutional order, all of that will shape, it seems to me, any attempt to begin those constitutional negotiations around separation if they occur. So in my view, and I think this would be the view of a court if it heard any cases about this, Indigenous peoples are not afterthoughts in any of this process. Indigenous peoples have to be front and center, and that would be clearly true in the prairies. I hope, maybe it's obvious that I hope we do not find ourselves there. I have no appetite or interest in having to watch those constitutional negotiations unfold. And driving from Edmonton to Saskatoon yesterday, after I taught constitutional law in the first class of the year, I was really struck by a couple of things. One is the great expanse of Treaty 6 territory. I started in Treaty 6 territory. I drove for 5.5 hours. I was still in Treaty 6 territory. But I crossed a lot of borders too. I crossed from city into parkland and then prairie. I passed the demarcations of a national park, Elk Island National Park, and then those slightly bizarre towering red poles at Lloydminster, which marks this bisected city between Alberta and Saskatchewan. I was thinking that our country is made up of these kinds of divisions and borders. Some of them are arbitrary and stark. Some of them are gradual and make more sense. But all of them capture something about the immense diversity of Canada. And if you drove the expanse of Canada, as I have, you would just encounter ever more of those divides. But the journey also reminded me of the famous lines, maybe the most famous lines, of the secession reference. And they were authored not by the judges of the Supreme Court of Canada, but by the government of Saskatchewan. Lines that were so powerful and true, the court gave them the pride of a block quotation in that judgment. The court quoted, the government of Saskatchewan said, "The threads of 1,000 acts of accommodation are the fabric of a nation." The threads of 1,000 acts of accommodation are the fabric of a nation. Those threads can seem awfully fragile, I think, in these kinds of moments, as we watch them fray or snap in our political upheavals. The task, I think, that falls on lawyers, on judges, and on law students, all of us, is to remember that our constitutional fabric is more durable than it sometimes appears, that new threads can always be added and replace those that seem to have worn away, that our constitutional connections of mutual respect, respectful disagreement, and the shared history, principles, and aspirations that make this Constitution worth all our efforts, not simply to protect, but also to value and to shape. All of that is the inheritance that we possess. I'd be really happy to take your questions. Thanks very much.
Thank you again, Professor Adams, for this fascinating and very timely lecture. So if you have a question, if possible, could you please come to the microphone here on the side and state your name and affiliation? And we have about 10 minutes for a Q&A session.
Hi, Eric. I'm Martin Phillipson. Hopefully you know who I am. If not, where have you been? So it's quite clear that jockeying for position, jockeying for resources within a federation is a constant competition. It's been going since federation. Are things really different now, or is it simply we're in a different political milieu where the temperature is being raised and social media creates movements that otherwise previously wouldn't exist, or is something actually really different? And are we, the second part would be, are we, however, in a new era of cooperative federalism, given Mark Carney's olive branches to Western Canada and other things where we need to worry less about separatism now and more about the equal distribution of the goodies that federation generates?
Thanks, Dean, for the question. And I sometimes am reminded, maybe this is a cop-out, but the saying, or more than one thing is true. So more than one thing is true in answer to everything you've raised. Yes, there are aspects of these dynamics that are as old as the country, and how could they not be? When you have I was doing some talk radio the other day about this, and someone said, well, Alberta's very different, right? You have to concede that. And I said, of course it's different. Have you been to Nunavut or have you been to Nova Scotia and Vancouver? Like every place in Canada feels different, and I've lived in many of them. And you're never going to, I think, get very far saying, yeah, but we're more different than you're different. Yeah, there are differences that stretch across this immense geography. That's just true. And navigating diversity and unity is the kind of perpetual challenge. And some of those are overlain with, the whatever particular crisis you're going through is. And for me, I just think that trying to figure out how to deal with both climate change and economic prosperity simultaneously that's a hard legal, social, constitutional problem. And different people have reasonable disagreements about where they would balance those priorities. But in the 1930s, there were sharp disagreements about how much the federal parliament could intervene in dealing with the Great Depression, and people felt very strongly that the parliament had to act, and others felt very strongly that it was inappropriate invasion of provincial jurisdiction. We navigated those intense political, constitutional moments, and I hope, will navigate this one. How do we do that? By listening to one another, by being prepared to reasonably disagree, and by also trusting in the democratic process that all of our constituencies, provincial and federal, have legitimate democratic accountability mechanisms and a role to play. When I sometimes speak about this in Alberta, I say, Federal law operates in Alberta because Canada is a democratically enacted or a democratically accountable political system in which everyone was able to vote in a federal election, and sometimes your party and your preferences have the moment and sometimes they don't. And that's been true of all of us. I'm sure you've experienced that at federal and provincial levels yourselves. And we lose something, I think, that's just absolutely critical about our parliamentary traditions when we say, well, if my policy preferences aren't currently the order of the day, then that government no longer has legitimacy to govern me. There are laws that I disagree with in my province, city, and nation. I follow them, and I hope to exercise my power in elections and through my exercise of my democratic rights to change those policies. So that's the part that is the same, Martin. But as I think I tried to gesture to in my remarks, there is a way in which this is different. It's taking on a new character. That character is that we are posing existential threats to one another. And I don't think that that is entirely removed from the way that the internet has shaped our political views and our ways of expressing ourselves. And so the minute you say that these are existential threats that we're posing to one another, then a whole suite of, I think, different constitutional and legal outcomes now become permissible. Because if you are trying to, if some other level of government is trying to destroy me, then you are paving the path to a more radical revolutionary grounds of constitutionalism. And I reject that premise that Canadians are trying to attack and destroy one another. I just don't see it. And I know that isn't to discount the ways that if your industry is being shut down or limited by various kinds of policies, that can feel very real. But that happened on the East Coast when they placed a moratorium on the cod fishery because of the collapse in fishing stocks in the 1980s. And if we just live in the present and think that this is all just happening to us now for the first time, if we lose our sense of our Canadian constitutional history, then I think we can elevate these moments into crises that is not appropriate. That's what I'd say about that.
Hi, Eric. It's Carrie Frock here. I'm going to be a little bit of a devil's advocate here, just because I want it to be a bit spicy. But I'm thinking, what if the Quebec secession reference in '98 was instead the Alberta secession reference in 2025? And the reason I ask is, and I'll see if you agree or disagree, there seems to be a strain of Quebec exceptionalism that goes through Canadian constitutional law. And I'm from Saskatchewan, so I think that to some extent people in the West feel that. Cases like Quebec and A, where, differences that Quebec had in whether women could get, unmarried women that were in common law relationships could get spousal support and property division, was essentially justified based on federalism, that Quebec is different. And there's a number of cases like that. And I'm worried, especially when it comes to, the upcoming Bill 21 appeal that's going to happen at the Canadian Supreme Court. So I'm just wondering whether or not you feel that there is a strain of Quebec exceptionalism that is flowing through Canadian constitutional law. And maybe, as a political question, to what extent that is feeding into these kind of separatist Western sentiments.
Well, in Alberta, you certainly hear a lot about Quebec, and sometimes it's a complicated relationship because sometimes it's criticism about perceived special treatment or actual special treatment or different treatment. And sometimes it's kind of emulation. Let's do what Quebec does. That seems to work for Quebec. We want to be kind of like Quebec. So those things are sometimes a bit of a paradox, and they play out in Alberta political culture. Maybe it's similar here in Saskatchewan. I know that less well. But I think it's fair to say that it's undeniable that Quebec has always had a unique role in the Canadian constitutional project, and that there are grounds, both structurally and in terms of the number of ways in which Quebec just actually is distinct, that have always mattered in Canadian law. So even though I'm of the view, and I just expressed it, that every province has a claim to a kind of distinctiveness, that just seems true to me based on my own experience and read of the history. Quebec says, yes, but when you put in a different language and a different legal system and the particular way that the history of this province unfolded, it just has those aspects of it that are not the ways in which Nova Scotia or BC or Saskatchewan have their own regional variances. And so Canada has always had to try and deal with that deep diversity in a country that also structurally had to account for provincial equality and also, frankly, our own instincts that we all want to be treated more or less equally. That makes sense to us, I think. It makes sense to law students. Don't give us different exams. We should all write the same exam. That seems fair. And so I think there's a deep instinct for equality that just pervades our political culture, and it has to sit alongside this also historical fact. Now, Canada also is going to have to, it's started to grapple with, it's going to increasingly grapple with the ways in which Indigenous nations form their own kinds of deep diversity of different legal systems, different languages, and you know the Section 25 jurisprudence is going to start to develop about whether or not those differences can also be reflected in constitutional law. So I don't think any of that is going to go away, and I do think that there is a delicate balance to be maintained between our openness to recognizing that deep diversity while also holding on to some kinds of structural equality that are also important. Because without that, we don't have a country that makes sense either. So I can only, I guess, say is that, yeah, this is a challenge in Canada. But it's not a new challenge. Done?
So,
Yeah, we have time.
One more?
Yeah, there's time.
Well, I am Tamara Buchwald, who Professor Adams kindly acknowledged at the front, partly because I'm his former colleague, but I think more especially because I am an exceedingly proud graduate and former faculty member of this law school, which continues to be a fine law school, and so congratulations to all of you who are here and part of it, and you're going to get a great education that's going to prepare you for a great career. And I was delighted to hear a quote from the Saskatchewan government in the Supreme Court reference. Anyway, and by the way, I can tell you Professor Adams is probably the most popular professor at the University of Alberta, which you can now understand. All right, now here's my question. I'm going to shift it a little off, kind of half sideways to the topic here. So my question is, you know, at the time of the constitutional reference and many of the other historical events that you outlined, Canada was not a terribly diverse country or nation. That has changed dramatically in the last 25 years over the course of my lifetime. Do you think that the increase in immigration, diversity in terms of national origin, you know, cultural and social practices, other identity markers, do you think that that has any kind of an impact on these constitutional discussions? That's kind of a left field question.
No, it's a good one, and of course that's also just a truism of Canada. But I don't think of those things as being structural changes to a place that was always diverse. So always a land of where Indigenous peoples governed that territory, always a place where newcomers are initially, but not exclusively from Europe. So, Canada's always had immigration from, in the 19th century, was the first waves of Asian immigration to Canada. And so, yeah, we've seen the composition of our public shift with new waves of immigration from new places. But to me, that hasn't and doesn't shape the way that both federalism and our Constitution has always had the same goal, which is how do we tie ourselves to an idea that binds us together while respecting the ways that we have to live individual lives of dignity and difference, but also within political communities that can be different from one another. So that's what I think is as was yesterday's problem, and it's going to be tomorrow's challenge too. Thanks, everybody. Just wish everybody a great term, and thanks for coming today.